Hey, this is Brian Jackson. I'm known as Action Jackson. I'm a criminal defense attorney here in Utah. My office is in downtown Salt Lake, and I'm doing a couple of videos to try and inform the public a little bit about the criminal defense system and how it works. And I really want to do a video on plea and abeyances. I did a podcast on it, but I guess videos are more acceptable in the internet world, so I thought that a video might work better. But I really think that the public needs to be informed about these plea and abeyances, and the big reason is because most of these plea and abeyances are entered in with the criminal justice courts, and the criminal justice courts, those are the city courts, they're not the big county courthouses. So if you're picked up with a misdemeanor or a city ticket, speeding ticket, whatnot, then you will go to justice court for that city where the crime occurred. And so there's a lot of DUIs and assault cases which have big consequences. An assault case can affect your gun rights, and DUI can get very expensive, and both of those crimes are enhanceable, as well as theft, and all those crimes are in city justice courts. And the problem is prosecutors hand these out like candy the very first court date. And it's good for them because they get an automatic conviction, and they don't have to do a lot of legwork in regards to investigating that crime. And the problem is for that individual is that they have now guilty on their record. But what makes it sound good is that you enter a contract with the justice court, with the city, and the contract is that if you do not commit any new crimes for a year or for 6 months, however much the prosecutor wants. And also they ask for a fee, so you'll have to pay usually some kind of fee along with that. Then they will dismiss the case after that time. So it sounds appealing because it's an automatic dismissal. The problem is, though, is that you have to plead guilty. You have to say that you committed the crime, basically. And like I say, most of the time the prosecutors make that offer on the very first court date. And basically, in a criminal system, you are innocent until proven guilty. And so it's the state's burden to prove that you're not guilty with the evidence they have beyond a reasonable doubt. And because of that, as a criminal defense attorney, I think it's important to look at the facts of the case and determine whether or not there's enough evidence beyond a reasonable doubt that this person is guilty. And so at arraignment, a lot of times, which is the first court date, I did a podcast on arraignments as well. Basically what happens there is they read you your rights. In most justice courts, they give you a form that you read and then you initial, and so the judge can save time on reading everyone their rights as well, or they put on a video and everyone sees it and then they sign a paper saying that they saw the video. Anyways, so the arraignment process and the arraignment stage, the only point of that is to notify you of your rights. And then you plead guilty and not guilty. And this is very crucial. And most people think that if they committed the crime, then right off the bat they should just plead guilty. But like I said, the whole purpose of the criminal justice system is that you're innocent until proven guilty beyond a reasonable doubt with the evidence that the state has. And so there's no reason to feel shamed or feel like you're being a rebel or anything if you plead not guilty. I think that it should be very standard for someone to plead not guilty and then be allowed to look at the evidence and determine whether or not there's enough, if they can prove their case. And if they can, and it seems like there's enough evidence there, then that's fine. Then you could move on and take some kind of deal from the prosecutor, what they may have to offer or whatnot, but it's another case for another day. But anyways, with plea and abeyances, yeah, that is curtailing the entire criminal process, the investigation process, and determining whether or not you are actually, if there's enough evidence on that side. And the problem with entering plea and abeyances for individuals is, number one big issue is if you are not a citizen of the United States, that can affect your immigration status. And you may think that, oh, this case is going to get dismissed, so it's not going to affect my immigration status. But in all actuality, immigration can look at that plea and abeyance as a guilty plea. And there are a lot of crimes that can affect your immigration status, which is another crucial article that I've written as well that I think everyone needs to know about. Basically, if you plead guilty to a crime that is more than 1 year in jail, that can affect your immigration status. But also, there's crimes called crimes of moral turpitude that can also affect your immigration status. So, for example, if you're charged with a crime such as domestic violence, assault, or any other kind of domestic violence charge, domestic violence in front of a child, or disruption of a communication device, all those domestic violence DV cases can affect your immigration status if you plead guilty to it. Also, crimes of dishonesty is a crime of moral turpitude, and crimes of dishonesty are crimes like theft, robbery, fraud, things like that. That can also affect your immigration. And so if you enter a plea and abeyance on a theft charge or a DV assault charge, that can affect your immigration status. So I would say be very wary of that. Also, even if you are a citizen of the United States, if you're looking for a job, or if you're looking for housing, or if someone's trying to do some kind of background check on you, they can see that. And they will say, hey, what's up with this guilty plea? And that you're, the place where you're trying to get a job or trying to get housing may just look at it as a guilty plea. And they may deny you getting a job or getting housing based off that and their standards. Also, another big thing with these plea and abeyances is that there's the condition that you cannot commit any new crimes within that amount of time. And so where that gets crazy is if you do pick up a new crime. And the problem there is that you pled guilty on this prior crime already. So the state doesn't have to do anything to prove anything about that crime, basically. And now you have this new crime that you've committed. And so you have this crime where you've pled guilty, and now the state can re-enter any kind of jail time or fine imposed on that sentence and have you serve that along with any new sanctions on that new crime. So you have a double whammy, and it's hard to negotiate out a case where you've pled guilty on one and then you picked up a new one, and that just doesn't look good. Obviously, a lot of things that prosecutors do is look at an individual's criminal history, and if they picked up a crime in a year or two, then they're unwilling to give an agreeable offer. So basically what I would say about a plea and abeyance is talk to an attorney before you enter a plea and abeyance. If it's your first court date, I would say plead not guilty, and at least have some kind of attorney look at it, talk to before you enter it. You may say that, oh, well, you know, it's a good deal and I just want to get this over with, but I would say that it is worth the time and the money. Sit down and talk to an attorney, kind of work out the facts of your case, see if there's anything there that can help you, and maybe get a better offer that doesn't involve a plea and abeyance, that doesn't involve pleading guilty. pleading guilty has a lot of consequences. So if you plead guilty, that's it. You're saying you're guilty. And what that means is that you're waiving a lot of constitutional rights that you have when you're charged with a crime. So when you plead guilty, you're waiving your right to a jury if it's a Class B misdemeanor. If it's a year in jail or more, you're entitled to a jury trial. And you're waiving your right to a trial. If it's Class B and below, you still have a right to a trial. It's a bench trial with a judge, but you still have a right to a trial. And also, you're waiving your right to cross-examine those who may testify against you, and you're waiving your right to basically have an attorney examine this case. And yeah, there's a lot of things that are involved, and it's best that you keep those those rights intact before you enter some kind of deal here. So that's my spiel on plea and abeyance. They sound good. They look like good deals, especially if you haven't committed any new crimes, but they do have consequences, and you just don't know what the future will hold for you. You may say, oh, well, that's easy, not to commit any new crimes, but a lot of times it's a lot more tricky than people may think, especially with a domestic violence case. The problem with that is a lot of times in domestic violent cases, people get a no contact order placed on them, and or a protective order, and basically what that is that you can't communicate with the victim. And what makes that difficult is that if you do, whether through social media or through third-person text, that can be a Class A misdemeanor, and that is a new crime. So if you commit, if you have an assault charge and they enter a plea and abeyance, and then they find out that you sent a little text message, that's an automatic Class A misdemeanor, which is up to a year in jail and $3,000 fine. Protective orders are crazy. I think there's got to be a better way, but right now that's what the courts are using. The way our technology is going, it's so easy for someone to commit, to violate a protective order. And if you enter a plea and abeyance, they just don't mesh, they don't go together. Obviously you shouldn't be texting that person anyway per court order, but you also want to make sure that you're not setting yourself up for a disaster. Another thing, if you enter a plea in abeyance and it's a theft charge, and you enter that and you have a drug problem, because a lot of people pick up theft charges because they have a drug problem, that can end up biting them as well, because it may be hard for them to control themselves. I mean, there's better ways to resolve a drug crime rather than entering a plea and abeyance. And I think that if you have an attorney on board and you talk to the prosecutor, you might find something that will first help you with your drug problem. I think that needs to be addressed, and get that taken care of so you don't pick up any new theft crimes, and then also some kind of agreement where the world doesn't come crashing down on you if for some reason you pick up another theft crime. Anyways, that's my video on plea and abeyance. If you have any questions at all, feel free to call our law firm, or if you have any questions from a relative or son, daughter that may be charged with a crime, feel free to give us a call, and we'll try and help you and walk you through your case and see what needs to be done on your case. Thanks.